Know the difference with Annex Wealth Management. Jill Martin is an estate planning attorney at Annex Wealth Management. Welcome back.
Thank you.
So we like to dot I's and cross T's here at Annex Wealth Management. When it comes to our clients, details matter. When it comes to estate planning, there are plenty of details to watch, including some gotchas that can come up with remarriages. To make things easier to keep track of, at least for me, we're going to use the Brady Bunch, kind of the classic American television story. There's Mike Brady, there's Carol Brady, Carol with 3 girls on her side, Mike Brady, and the boys on the other. You're familiar enough, right?
Absolutely.
Okay, good. If Mike Brady doesn't update his will after marrying Carol, remember they're putting the 2 families together for the bunch, and something happens to Mike, everything could go to the boys if that's the way it was structured. Basically, Carol would be out. Is that right?
Well, it's not quite that simple. So what happens, though, is anytime you have a remarriage, right, you need to revisit everything, whether it's beneficiary designations, whether it's your will, whether it's your trust, because divorce, what that does is it automatically takes out that spouse who is now an ex. That's within your estate planning documents. That doesn't apply to beneficiaries. So they may be treated as predeceased. So yeah, maybe it would go to the boys then, but maybe he wants it to go to Carol. So what happens is it's a totally changed dynamic of this remarriage. So you really want to make sure that you're looking at your estate plan, looking at all your beneficiaries to figure out what's going to happen and what do I need to change.
Right, because what he wants to happen, if it's not legally set, won't happen.
Absolutely. And so that's the key. We can't just assume that the remarriage fixed it or solved it.
How about this slightly different scenario? Mike passes, and it's all left to Carol with the understanding that she'd provide for the children, including the boys. There's a possibility that might not happen, right?
There's a big possibility that might not happen.
If Carol was evil.
Well, not even if Carol was evil. It could happen by just accident, right? Let's look at 2 IRAs. Mike has an IRA, Carol has an IRA. If Mike leaves his IRA to Carol, and Carol's beneficiaries on her IRA were only her 3 girls, she hasn't done anything to not provide for the boys,
okay, right.
But what's happened is her beneficiaries are her 3 girls, and so that's where Mike's IRA and her IRA go. So we've disinherited the boys. Carol isn't evil in that she's done that, but that's likely not what Mike wanted to have happen. So that's where more planning needs to come in.
Okay. Before they moved into that super cool 70s split level house, right, an estate planning attorney needed to be in place.
Not necessarily,
Really?
But anytime you've got children from prior marriages and you come to a new marriage with assets or something, right? Having some type of a marital agreement or a prenuptial agreement helps really outline how are we going to manage our new marital finances. And that's a really important step that some people don't undertake. But if you didn't do it before you got married, you can do it after. You can still contract with your spouse to say, these were my assets and I want them to go to the boys. And these were my assets and I want them to go to the girls. And here are our marital assets, which we'll split among the 6 of them. So there's things you can do after the fact, but sometimes it's easier to do it beforehand.
In the case of the Brady Bunch, the kids were in middle school, high school-ish, and Mike and Carol's money was commingled. It was joint, correct?
Let's assume, sure.
Let's assume, okay. So the kids grow up, they're in college, and then they moved out, and they're totally empty nesters. Is there any obligation from either of those parents to pass anything on to the kids?
No. I mean, you as an individual with money can give it to whoever you want to. Obviously, when they're spouses, it's a little different because spouses have certain statutory rights to get money from a spouse who's deceased. That doesn't pass on to children, right? If all of a sudden, Danny, you have 2 kids and you decide that you're not going to leave them a dime once you and your wife are gone, they don't have any legal claim to say, I should have gotten something from Dad. Children don't have an inherent right to inherit.
So if Dad wanted that, he should have stated that and set that up.
Yes, okay. Absolutely.
All right. Estate planning and remarriages, what are the gotchas? We're using the Brady Bunch as our family example. Here's one that might hurt the most. I think you got at it a little bit at the beginning. Failure to protect your estate from your first spouse. Now, in the Brady Bunch example, Mike Brady was a widower. Carol was divorced. If things weren't absolutely clean with beneficiary designations, life insurance plans, if Carol passed, first husband has a claim.
Well, not a claim. So what you have to do there is Carol needs to go back and look at her retirement account and figure out who the beneficiaries are. If her ex-husband was still listed, if she were to die, he's going to get that. That's where he would have a claim. Just because he's an ex-spouse doesn't mean he would have any authority. But if he's still listed as the beneficiary on her account, that's where he's going to get it. Now, he may decide, oh, I don't want it. Out of the goodness of my heart, I know it's going to go to my kids, my 3 daughters, right? Maybe he'd be okay with that, but maybe he wouldn't be. And then all of a sudden, what did we just do?
I like that you have hope because that's what the 70s had with the Brady Bunch. All right. Joe Martin, estate planning attorney at Annex Wealth Management. Thanks for jumping on.
You're welcome.